And welcome back to Law&Crime Trial Network. I'm Stacey Delikat. Thanks so much for being with us this afternoon. 3 big trials we are keeping an eye on today. We want to get you right into the Georgia courtroom, or rather the Florida courtroom, where Grant Amato's trial continues. His defense attorney has just begun his closing argument. All right, we're about 45 minutes into the defense attorney's closing argument. I want to bring in Gene Rossi, Law&Crime legal analyst, who's joining me today via Skype. Thanks for being here as always, Gene.
Good to see you, Stacey.
So obviously the defense attorney here hammering hard the fact that he says basically there was shoddy police work. They didn't collect DNA. They didn't test the fingerprints they were supposed to. What do you make about this? Will it be enough to poke holes in the prosecution's case and raise some reasonable doubt?
Yes, in a CSI society, jurors expect almost perfection. That's why oftentimes you'll have an instruction on CSI and crime scene investigations. And this defense attorney, Mr. Jeff Dowd, he's doing a really good job. He's throwing some left hooks, some right hooks, and there is not one witness that he doesn't find some fault with. And he really took some jabs and hard punches at this Blake guy who came out of nowhere with the photos, a stolen gun, things like that. But as someone who's done a mock trial and talked to jurors after trials, when you don't have any DNA, when you don't have hair, semen, something from the alleged killer, the defendant, that goes a long way. It really does. And it raises the bar for the government if you don't have some unassailable evidence that connects the defendant, even if it's circumstantially, to the scene of the crime and the alleged crime.
It's an interesting point, that you said in the CSI age that we live in, right? Everyone watches true crime shows and all we hear is DNA, 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 that jurors, the public expects this. So even though the prosecution said, look, here's why we didn't need to collect DNA, why this didn't call for DNA, it would have been a red herring, that argument doesn't really fly here in your opinion.
Right. And for example, if you don't have fingerprints on a gun when there should be fingerprints, it's very hard for a prosecutor to argue, hey, jury, there's no fingerprints, but that doesn't mean the defendant didn't do that. That argument is a little weak. I've been in that position in one of my cases where there weren't any fingerprints on a rifle, and there should have been, 10 or 12 fingerprints. So when Mr. Dowdy's saying there's no DNA and you got these graphic photos, and here's the other thing. He's doing a really good job of making lemonade out of lemons. You got these graphic, brutal, bloody photos, and he is embracing them and saying, listen, if my guy Grant Amato did this with all this blood and carnage, you would think there'd be something on him.
Right.
When you went through his shoes.
In his car, in the hotel room. That stuck out to me, too. I mean, that's a big question. How do you get out of this bloody crime scene with no blood on you? So that's certainly something I think jurors will be wondering as well. Gene's sticking around. We're going to take a quick break. When we come back, much more on these closing arguments out of Florida. Stay with us. What was that little snippet that Gene and I were just discussing earlier about the prosecution explaining why they did not do DNA testing, why it wasn't needed, according to Dominic Leo, the prosecutor. So, Gene, what do you make of that explanation now that you hear it directly from his mouth? I mean, is there a point there? Look, he lived in the house. His DNA is going to be on the doorknobs. It's going to be on the countertop. So why bother testing for it?
With the utmost respect to Dominic Leo, when a prosecutor does a rebuttal, you got to get up there, fire and brimstone. You get up there with confidence, with vigor, with offensive statements. He looked defensive, and here's why. His analogy about the guy who goes in and murders somebody and has the knife in the car, there's DNA on the knife. This case, you would think there'd be some DNA on Grant Amato, so his analogy actually hurts him. The second thing he did, in addition to being, body language, demeanor is a little defensive, he should be pounding this, Stacey. Circumstantial evidence is powerful, if not more powerful than direct evidence. It's great to have a witness that saw the murder, that saw the scene of the crime, and they can testify based on their eyesight. But circumstantial evidence will be a jury instruction. He has to pound that the circumstantial evidence all points directly at Grant Amato. And the last thing I want to say is this: the motive in this case is a tsunami. He had a person in Bulgaria, this girl he was in love with, and he was sending her money. He tried to claim life insurance proceeds after his parents were killed. How much more circumstantial evidence can you have than that?
Right. And he, of course, over the course of his almost 2-hour closing does touch on those points as well. I think this was a kind of weak point for him. As you mentioned, he seems defensive and he says, so what do we need? We need eyewitnesses. We don't have any eyewitnesses. The eyewitnesses are dead. There was no one outside the house. He sort of, here's everything we don't have in this case. Talk to us about what we do have, what will convince the jury, right? Let's listen to a little bit more. So here the prosecution is saying, okay, the defense says this was a random intruder. So what? It played out like this, right? He's giving us the hypothetical, very sarcastic, right, Gene? What do you make of this tactic?
Okay, I feel much better. This is good. All right. In addition to doing the fire and brimstone in rebuttal, you get engaged in mockery politely of the defense argument. And he's doing this very well. He's talking about, I call it the Bigfoot. Someone else went in, it was Bigfoot, the random intruder. He's doing a good job mocking this intruder theory.
So you are all for this tactic. Here his case is strengthening a little. All right, well, we're going to see how he did for the rest of it. We're going to take a quick break. When we come back, much more on these closing arguments. Stick around. We'll be right back. So, Gene, there he is explaining away our big question. How did Grant Amato get out of this bloody scene with no blood on him? And he says, hey, it wasn't that bloody a scene. What do you make of that?
I think that's a good part of his argument. I like Dominic Leo's argument on that one, because he's now explaining the absence of evidence. How is it possible that Grant doesn't have a scintilla of DNA on him? And he's explaining that. He's embracing that, because that's part of Grant Amato's MO. He wanted to kill all 3 people, his parents and his brother, Cody, without leaving any print, without getting anything on him. And he's explaining that. That's very good. I like it.
I agree. I mean, this was a big question. We just spoke about it a few minutes ago, so here's what he's telling jurors. All right, we're going to take another quick break. When we come back, we will hear the rest of this rebuttal as the jury gets ready to take this case. Stick around. We'll be right back after this quick break here on the Law&Crime Trial Network. So when the defense delivered their closing, he basically went through every single witness and tried to either attack that witness's credibility or explain why that witness had given incomplete or misleading testimony and so on and so forth. And now we see the prosecutor in his rebuttal going back through that list of witnesses again and saying, yeah, here's why they're wrong. Gene, this is what he's supposed to be doing, right?
Right, but I got to caution, when a defense attorney or even the government attacks a witness that the jury probably believed and liked, that's dangerous territory. I'll give you one good example. When the defense attorney was criticizing Geraldine Bly, I watched her testimony Monday, and I thought she was a terrific witness for the government. I found her extremely credible. And when the defense attorney was attacking her credibility, implying that she was kind of not telling the truth, I think the defense attorney's credibility level with the jury went down a little bit, and Dominic Leo is doing a great job of shoving that back into the defense attorney's face, because Geraldine Bly was a very credible witness. There were a couple other things that I liked, that the defendant kind of knew how to navigate the blood because he's a nurse.
That's a good point. Yeah, you're right.
I thought that was pretty good. I like that one a lot.
Yep. Good points here. Good little nuggets that you picked up there. Well, this rebuttal continues. As you can see, we're going to take a quick break. We'll be right back with much more on Law&Crime right after this. And there you have it there. The prosecution wrapping up its rebuttal, saying, look at the evidence. There's 300 pieces of evidence in this case. It's not a manufactured case. Don't believe the defense that any of our witnesses lied or did a shoddy job. They did their job. Gene, overall, how do you rate this rebuttal?
I thought that rebuttal was excellent. And I was a little hard on Mr. Leo at the beginning, but he picked up steam. I thought he did a good job. You know, I'm a perfectionist. There was one thing, I didn't hear it unless it was during a break. I didn't hear him talk about motive, the
The motive.
Bulgarian. I don't know why he didn't mention that, because that's that cloud. Motive is not an element of the crime. We all know that. But I love talking about motive because it explains human behavior, whether it's hatred, jealousy, greed. And this was a combination of romanticism and greed. And he didn't talk about it unless I missed it.
I agree with you. I didn't hear him bring it up there in the rebuttal, and I do think that that's such a big part of this case. Grant Amato's obsession with this woman he'd never met, who basically just lives on the internet, stealing all of this money to pay for pictures and video of her, and then being furious at his family when they try to cut him off, trying to claim the life insurance afterwards. So I think that those are really key points as well, though I don't think the jurors have forgotten that from the trial. I do think, though, it would have been good, as you said, to hear him hammer it home once more. So where do we go from here? Well, the judge will be reading the instructions and the jury will get the case. So it's hard to predict, but what's your feeling on this as the jury prepares to deliberate, Gene?
I think the defense did an excellent job. You know, I always say trials are poker. You're dealt a hand. Mr. Dowdy did the best with the hand that was dealt him. He tried to raise some reasonable doubt, but I like that phrase that Mr. Leo used, that, you know, the defense says this is manufactured evidence. I suggest that this is a case on their part. It's manufactured doubt. The doubt that they talk about doesn't exist. Geraldine Blay was a good example. I think if I had to bet money, you're probably going to have a guilty, but I could be wrong.
All right. Well, we're going to hold you to that. I'm going to be collecting, but we'll see what happens. I mean, and I think also, Gene, though, you know, earlier when the defense was doing their closing and they really sort of went hard on this point of basically shoddy evidence collection and why was there no DNA, I do think that some jurors may still grasp onto that. Do you?
Yes, but I do want to get to that point, but I forgot to mention, whenever you have a multiple murder of a couple and a child, just like the McStay murders in California, the jury wants to find somebody to blame. They got to pin the murders on someone. So you have that subconscious force. But let's go back to deliberations. If there are 1, 2, or 3 jurors who are holding out with reasonable doubt, you're going to have, you know, 9 or 10 jurors that are going, come on, this is guilt, and that pressure gets overwhelming. And I had one jury that was 10-2 for guilt, and the 2 jurors that came out, they were crying when we declared a mistrial. So there's a lot of pressure on the people that are holding out.
Yeah, well, we will see how it plays out, how long it will take them to reach a verdict and so forth. As I mentioned, the judge right now delivering instructions, and we'll see when deliberations begin. We're going to take a quick break. Gene, thank you for all your insight on this. I know you're sticking around. We'll be right back after this with the other top trials we are following across the country. Stay with us.